my name is Jack Stallard. I am a construction payment expert here at LevelSet, and I work on our training and onboarding team to prepare our users to send out these kinds of documents on their own and pursue payment to become payment heroes. And just a little background about LevelSet. We are here to be a payment help to our customers. There are thousands of contractors and suppliers who use us to protect and speed up payment every day. With LevelSet, you can send notices and payment paperwork electronically, as well as by any required mailing formats. We can find and verify property and job details for you with our research team. And we can also send you alerts when payment problems arise on jobs that you're working on or jobs in your network. Plus, there are tons of other features that we could spend all day talking about. But today we're here to talk more about the California Prelim. And so what we're going to cover today, we're basically going to talk about what a preliminary notice is, and specifically what the 20-day prelim in California is, how it'll help you get paid, how to properly or accurately send a California 20-day prelim, and then we're going to talk about some different ways to streamline that process. And then at the end, we have some time set aside for Q&A. So please feel free to ask questions in the Q&A section. Don't be shy. If you're thinking about sending in a question, someone else probably is too. So please don't be afraid to send a question in the chat or in the Q&A field. We will get to those at the end of the webinar, though. We will be going through kind of all of the different resources first, and then we'll be talking about any questions you might have. And also, after this, we will be sending you the recording of this so that you'll have this on hand in case you have any other questions or you just want to double check what we discussed today. And so you're probably asking yourself, if you don't already know, what exactly is a 20-day preliminary notice? You've probably heard of it, but it's not always something that everybody is familiar with. But if you work in construction in California, more likely than not, you know about this document. But these are preliminary notices sent at the start of all types of construction projects in California. So whether it's residential, commercial, state, or federal, these notices are going to come into play, and they're going to be super important for obtaining payment in situations where you might not get paid on time. And the purpose of this preliminary notice is pretty multi-layered, and we'll be getting into that, starting with the different ways that your role on a project or the type of project can contribute to those different layers. And so starting off with general contractors on private construction projects in California, GCs typically must send a preliminary notice, especially if the job has a lender on it, within 20 days of providing labor or materials. It must be sent to the lender, and it can be sent late. On the flip side of that, with public projects in California, general contractors are not usually required to send a preliminary notice, since general contractors will usually not make a claim against their own bond for non-payment. Since there are no bond claim rights in that situation, there is no preliminary notice requirement. And then for subcontractors on private construction projects, subcontractors and suppliers must send a preliminary notice within 20 days of first providing materials or labor, and it must be sent to the owner, the general or prime contractor, and the lender if applicable. This can also be sent late. And then on the public projects where you are fulfilling the role of a subcontractor, you must send a preliminary notice 20 days after first providing that labor or materials, and it must be sent to the public entity, the prime or general contractor, and the surety if applicable. And just like the other forms, you can always send this one late. And so while we've been talking about the sort of definition of what the prelim does, you're probably thinking, why should I send this? This is typically a visibility document. It's primarily meant to share information with people up and down the chain on your project. So it lets other people know that you're here on this job, this is what you're doing on the site, and this is how to get a hold of you if they need anything from you. Basically, it's a way to ensure that the project is going to run smoothly because it creates clear lines of communication. But it's important to remember that they are required documents as well. In fact, failure to send a prelim in California is grounds for disciplinary action under the Contractors state license law. According to California Civil Code, the preliminary notice is only optional if the work is less than $400. So this is definitely something you're going to want to send out. And failure to provide notice is actually fatal to mechanics lien and bond claim rights in the state of California. In other words, if you don't send your preliminary notice correctly, you can't later file a mechanics lien, a stop notice, or bond claim if unpaid. People who are required to receive these notices, who are typically general contractors, property owners, and lenders, rely on notices to paint a picture of all the parties that are working on the project. This makes it much, much easier for them to facilitate smoother payment on the job because there are clearer definitions of who is doing what and who has already sent this visibility document out. And so that's going to bring us to getting paid faster. It might surprise you that construction companies that send preliminary notices get paid significantly faster than the companies that don't send them. That's because you're prioritizing your invoices when you send notices by making sure they are visible. And what's the result of getting paid faster? Much better cash flow. And finally, sending a preliminary notice is required in order to preserve the right to file a valid mechanics lien or bond claim in the chance that you're not getting paid for the project. Since this one document can be sent at the beginning of the job, you can basically create a safety net you can fall back on by filing a valid claim if you're not paid. And anytime you encounter slow payment, this is great insurance for later. The problem for contractors and suppliers, though, is that you can never know when your lien rights will be needed. It's really unfortunate when someone gets stiffed on a job or they're completely without options because of missing this simple requirement. And so we see these unfortunate circumstances all the time, and it creates a very difficult and painful position. And you can bet that those in this situation would give almost anything to go back in time and just send that little notice. And so that's why we're here today to talk about ways to send this and how important it is to get this out there. And so your next question is probably, if I don't send a prelim within 20 days in California, can I still file a lien if I don't get paid? So this is one of the most common questions that we hear at LevelSet. And in California, there are very specific and strict rules regarding the preliminary notice to owner. For full protection, California usually requires preliminary notices to be served no later than 20 days after the claimant has first furnished labor or materials, which is where that 20-day prelim title comes from. A lien claimant who failed to provide notice within 20 days of first providing labor or materials may provide the notice at a later date, but they will only retain lien rights for materials or labor furnished within the 20 days preceding the late notice, as well as any contributions thereafter. So that's where that can be sent late line comes in. And so this is something to keep in mind if you're ever in a situation, where you'd like to send this late rather when you've missed the deadline. And so if it's been more than 20 days since you provided labor or materials and you forgot to send the notice, you won't have the right to file a lien for those specific amounts. And if you don't provide a preliminary notice at all, you will not have the right to file a lien in California, meaning you will lose your lien rights. And so a really important question here is, who needs to send this document? And so the short answer is basically everyone: contractors, subcontractors, material suppliers, and vendors. Additionally, general contractors on private projects that involve a lender will also need to send this, but a good rule of thumb is to send a prelim as a proactive tool. There are two specific parties, though, who are exempt from California's notice requirements. One would be a pure laborer who is not required to give preliminary notice, and anyone with a direct contractual relationship with the property owner, they're only required to give preliminary notice to the construction lender if the project has a lender. So the two exceptions are laborers that are not doing any other specific roles on the project, and then if you're in a direct contract with the property owner, and if there is no lender involved. But otherwise, basically everyone does need to send this or is highly recommended to. And so next, we've talked about who needs to send it. So who needs to receive this notice? For private projects, California requires that the notice be sent to the owner, general contractor, and lender if there is one. And then for public projects, preliminary notices, it must be sent to the public agency in charge, as well as the GC and the surety. And so something that is very difficult to find is the information for the owner designee, general contractor, lender, or surety. And so this is definitely one of the most difficult tasks when preparing to send one of these prelims, and figuring out the identity of these parties involved can sometimes you'll run into situations where there's no easy solution for this. In some states, finding the property owner may be as simple as searching a county assessor's website or going into the county index. However, California doesn't provide property owner information online, so you often have to make a phone call. But On the flip side of that, Orange County and Fresno County won't give out information over the phone specifically. Many other counties will, but it just depends, and this creates some roadblocks for getting through to this information. And so if you're able to go personally into the county assessor's office, that's the most accurate way to obtain the information. It may be inconvenient to go into the county assessor office to verify who the property owner is each time you begin work on a project. So this can be, extremely fruitful, but it can also end up being kind of a big use of your time. So because of the difficulties presented with these different options, since you can't access this online and you will either need to call or show up to the county assessor's office, it's becoming much more common to send out preliminary information requests at the start of a new project. Basically, companies will send out an information sheet that's sent to be filled out and sent back with any contracts associated with the project. That makes things way easier since it gives you everything you need from the get-go. Additionally, with LevelSet, we can make the whole process much faster, much simpler with our Scout feature. Depending on the package tier, Scout allows a team of LevelSet researchers to go find this hard to get information for you, either automatically or upon request. That means you don't have to dig for any unnecessary data trying to find the little bits that you need, and we'll take care of all of that for you. This is information that can sometimes take hours or days to find, and we've got it down to sometimes even just a few minutes. And any way you choose to go about getting this information, though, it's really important that you get it in a timely manner so that you don't miss that 20-day mark for delivering this document. That way you're able to retain all your lien rights, and you're also delivering this to all the parties who need to see this. And so we talked a little bit about how you can send the preliminary notice late, but we haven't really covered whether you can send it early. And so the short answer to that is yes, you can send a preliminary notice early or late in the state of California. You can even send one before materials are shipped if that's something that's going to be happening on your project. So the rule is that the preliminary notice must be sent within the 20-day notice period. Actual delivery is not required within that period. The requirement is considered met if properly sent within the period, but it's best to be proactive and get it out as soon as you can. If you miss the required date, it's not a complete loss, but California prelims can be sent after the due date, but not too late. As we discussed earlier, if it's sent late, a lien claimant who does so will only retain lien rights for materials or labor furnished within the 20 days preceding the late notice. A notice should be filed even if it is late, because the failure to provide a notice at all is absolutely fatal to a California mechanics lien. So you might as well go ahead and send them in early, get it done and out of the way, so then later on you don't have to worry about sending anything like a notice of intent to lien or a mechanics lien, or following up with a late preliminary notice. And so another question that might be coming to mind is, when is a 20-day preliminary notice requirement considered satisfied? So the preliminary notice is considered delivered at the time of mailing. And again, best practice is to get these notices out as early as possible. So the earlier you mail this out, the sooner that these requirements will be satisfied. Also, I do want to point out that the notice must be delivered by certified mail or personal delivery with evidence of the delivery. So it's important to not only deliver this notice, but to keep evidence of the delivery so you can later prove compliance with the requirement. And so you may also be thinking, like, are there any cases where you want to send multiple notices? If there's a situation where you feel like you have multiple contracts or something where you need to send out more than one of these. Typically, if work spans over separate lots, parcels, or tracts of land, one notice to owner is still acceptable as long as they're owned by the same person and there's only one prime contract. If there's more than one prime contract and or owner, then you'll want to send multiple preliminary notices. Even if it is not necessarily required, it's definitely the safest way to proceed and a good way to completely cover your bases. And so you're probably also wondering what kind of information you need to include on the document. So California's preliminary notice may look a little intimidating at first, but it's actually a very simple form once you spend a little bit of time with it. California prelim notice requirements are very similar to the requirements of other states, and generally speaking, they are good faith collaborative documents that benefit all project participants. Like we said at the beginning of this, they're visibility documents that are meant to provide clear communication to all parties up the chain on a project. And this here is our LevelSet preliminary notice for California. And so all of our prelims have this first friendly professional cover page that provides all of your information. And then on the next pages are where we'll include all the statutorily required language. So it protects your lien rights while also maintaining your relationships and basically keeping a friendly demeanor with your customer. And so you're probably asking yourself, how do I start sending these on all of my jobs? And so I'm sure at this point in the webinar, you're all convinced that you need to send these on everything, but you might still be thinking like, how do you do this without it turning into a ton of work? And so that's where LevelSet comes in. So starting a new process can be super intimidating and it's a lot to learn and keep track of. So that's why we exist. We are built to have these requirements as part of our platform to tell you when you need to send things and how they need to be sent. We're here to save you a bunch of time and make it easy so it's not adding extra work to your plate. So as soon as you would enter any project information into LevelSet and the dates you're beginning work, typically will then calculate and track all your deadlines for you based off of the state you're working in and your role on the project. And depending on what your customer's role is and the type of project, we will tell you when and how and if you need to send this document. And so with the preliminary notice creation, we have the most up-to-date, legally accurate templates for preliminary notices in every state, including California. And we mail the documents for you. We'll upload all the documentation and proof of mailing to your LevelSet account, where it's stored indefinitely. You can access digital copies, you can download it, email it. It's yours for your records, and you'll be able to reference it and go access it with just a couple of clicks. And so we spoke a little bit about job research, especially when we were talking about the different ways to obtain information from the county. And so something that is super important about LevelSet and super helpful about LevelSet is that we have our Scout research team and our Scout research solution to give you access to the job and property stakeholder details that you need to have to make these preliminary notices accurate. We confirm all the details that you give us, and then we'll find anything that you don't already have on hand. And then from there, we'll mail the documents for you and we'll upload all the documentation and proof of mailing to your LevelSet account, just like we said before, where you can just access it with a couple of clicks. And so also, if you're looking for any additional legal assistance when it comes to reviewing contracts and the steps you can take proactively to ensure payment on your jobs, we have an amazing network of vetted construction attorneys to help you out. We have local California attorneys who you can partner with to help you with current payment related legal issues or help you be more proactive to avoid these kinds of things in the future. And so this is part of our Legal Guard program where you'll be paired, like I said, with a local construction attorney, and they can do anything from reviewing contracts and other documents to basically being your legal partner through LevelSet. And so it would just be a one flat yearly rate for proactive and reactive legal services. And so if you're ready to get started and you're interested in requesting a demo from LevelSet from our sales team, you can go to this levelset.com/request-demo link to request a demo from one of our sales reps. And you'll be able to access that link directly when the webinar is sent out with the recording. And so now we've gotten to the Q&A portion of our webinar. And so if you have any questions, please go ahead and drop them in the chat or in our Q&A function up above. And please, if you feel like you have any confusion about anything, or if you'd like something cleared up, it's definitely more likely than not that someone else attending the webinar has the same question. So please don't be shy. All right, so Peter said that he is in Georgia. So technically, depending on the state, there are different requirements, and LevelSet has a ton of blogs and articles that you can use to general contractor, excuse me. So generally, you can go and see on LevelSet. If you go to our California Prelim blog, you'll see what's required of you. Depending on what like the requirements in California dictate, it depends. Certain types of jobs, as well as the role you might play on the project, and the person who's either hiring you or who the property owner is, can all play different roles in determining whether or not you'll need to send this document. Okay, and so Anita asked to explain again about whether it's okay to send late after 20 days. So when I was explaining when it's okay to send the document late, what happens is whenever you send it after the 20-day deadline, the amount that it covers changes. So the idea is that if you send it by the 20 days initially, then that covers the first 20 days of work if you were to go file a lien. But if you were to send it late, then that 20 days would be adjusted to 20 days before you sent the document, and then anything thereafter. Does that make sense? Okay, great. And yes, Peter, with the general contractor role on a California project, with the 20-day prelim, unless there's a lender present, you generally will not need to send a preliminary notice, but it just depends on the different parties on the project. All right, do we have any other questions today? Happy to give you all a couple minutes to come up with anything. I know we just went through a lot of information, so I totally understand if you need a second to kind of digest everything. So Anita, this is going to be sent out to you with the slides as well as a recording of the webinar that we just did. So you'll be getting a copy of all the slides with all the links that were embedded into the different pages, and you'll also get the video of me presenting. So you'll get to see any explanations I gave again, as well as all the plain text on the webinar. And yes, Peter, these are going to be sent via email, so you'll get the file as well as the recording. All right, well, I'm going to stay in our webinar until about 1:30, answer any more questions you might have. And then from there, I just want to say thank you, everybody, for coming today. I know this is often an intimidating document to start sending out, and it's definitely a great learning about it is a great way to start becoming more proactive and protecting your lien rights from day one. All right, and so there are no more questions. I am going to stay, like I said, but if you don't feel the need to stay and you don't have any other questions, thank you so much for coming to the webinar, and I'm happy to give you a couple more minutes back in your day. So Peter, typically what I would recommend anytime you have any legal advice questions, if you're a LevelSet user, we have a free legal advice platform called the Expert Center. If you wanted to ask that question, but since I'm not an attorney, I typically don't give legal advice because you definitely want to go get legal advice from an attorney or lawyer rather than from me. But we do have some resources available to you on LevelSet's website. If you're not a LevelSet user, you can view conversations had between our LevelSet users and construction attorneys and payment experts in the industry. All right, well, it looks like we don't have any more questions, so I'm going to go ahead and end the webinar now. Or actually, so Peter, you're asking, could you mail you're asking about the mechanics lien? So typically with the mechanics lien, there is going to be a required mailing format associated with the delivery of a mechanics lien. And so I believe just like the California preliminary notice in general, the two types of delivery that are acceptable are certified mail with return receipt or in-person delivery. All right, well, thank you again, everybody. And you'll be getting the recording as well as the slides for this sometime tomorrow. But I hope you all have a great day, and I'm looking forward to seeing y'all become payment heroes if you're not already a LevelSet user. Thanks.